All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and its honorable court. This honorable court is now in session. Please come to order.
Good morning, everybody, and welcome to the remote version of the District of Columbia Court of Appeals. We appreciate counsel's flexibility in shifting over to remote arguments in light of the possible weather concerns. And we have two cases on this morning's calendar. The first of them is In Re Estate of Rosetta Jenkins, Edward Jenkins appellant. It's case number 21 PR 900. We'll hear first from Ms. Ugolini. You may proceed.
Thank you. Good morning, and may it please the court. I'm Francesca Ugolini, counsel for the appellant, Edward Jenkins. The question in this appeal is whether Edward and Rosetta Jenkins had a common law marriage at the time of Rosetta's death in 2007, such that Edward is her surviving spouse and heir. The significance of that ruling will affect whether Edward will share in any of the proceeds from the sale of the marital home that he and Rosetta purchased together in 1996, but that is titled solely in her name, and she died without a will. The test for a common law marriage in DC is a mutual express agreement to be married, followed by cohabitation as spouses. And there is no dispute in this case that Edward and Rosetta lived together as spouses for 35 years until her death. The dispute is whether there was a mutual express agreement to be married, and more specifically, whether their 1972 wedding counted as an agreement, given that Edward was not actually free to marry at that time. This court's precedent in Matthews v. Britton answers that specific question in Edward's favor. In that case, the court held that the agreement can occur before the impediment to the marriage is removed, so long as the couple continues to live together as spouses after the impediment is removed. And it is undisputed in this case that that occurred. The probate court went astray in this case by holding that the agreement could only occur after Edward's divorce in 1997 from his first spouse, and that it was critical to determine what Rosetta knew or did not know about that prior marriage. In the Matthews case, and also in the Thomas v. Murphy case that the Matthews court relied on, this court squarely rejected the notion that the agreement has to occur after the impediment is removed. The specific language in Matthews is that it is not to be expected that parties, once having agreed to be married, will deem it necessary to agree to do so again when an earlier marriage is terminated. And the court explicitly held that it is irrelevant whether one or both parties has knowledge of the impediment. In its answering brief in this case, the appellee did not respond to our argument regarding knowledge, and that issue is waived under the rules of waiver in appellate practice. Unless the court has any questions about the common law marriage issue.
Can I ask you, I guess, a question that's maybe logically a step earlier, which is the question of whether we have jurisdiction to consider this appeal at this time, given that the order, I'm sorry, I'm getting cases confused, excuse me. Let me ask you, I was getting cases confused. The question I meant to focus on was the disqualification question. And I want to make sure I understand the position that you're taking with respect to disqualification. Your opening brief definitely argues that the trial court erred in concluding that there wasn't prior representation of Mr. Jenkins by Mr. Hardy. But it at least arguably seemed not to be requesting any relief on the merits looking backwards, and instead only to be requesting forward-looking relief. And in the responsive brief, your opponent characterizes your brief that way and says that's all that you're asking for. And in your reply brief, I didn't see you disagreeing. So I just want to make sure, is that right? Are you not raising that claim of possible failure, erroneous failure to disqualify as a basis for overturning the judgment that's in front of us? And are you relying on it solely looking forward?
Yes, that is correct. I don't think the disqualification issue in this case warrants is a separate basis for vacating the judgment, but it still is a relevant, it has current relevance in the case. There are ongoing proceedings in the probate court. And of course, after this court's decision, the case will be remanded for the probate court for a distribution of the estate property. There was actually a status hearing in the probate case last week that I participated in, and the appellee, Ms. Johnson Butler, was asked whether David Hardy continues to represent her in the probate case, and she answered yes. The clerk also, I guess, attempted to call Mr. Hardy to see if he wanted to participate in the hearing. And his response was that he was unsure of his status in the case. So there certainly is a continuing question of whether Mr. Hardy will participate in this case when it is remanded to the probate court. And I think the issue, so the propriety of his continued participation in the probate case is still a live issue, and I think warrants clarification.
This gets me to the interlocutory appealability issue that I was jumping the gun to get to, which is if you're looking at that as really a challenge to who will be representing your opponent going forward in this matter, and the judge's refusal going forward to remove Mr. Hardy, that raises a question in my mind, at least, about whether that forward-looking question is properly in front of us. It's my understanding that generally you can't interlocutorily challenge a judge's refusal to remove opposing counsel in a case to disqualify. And so addressing that issue looking only forward seems very similar to kind of taking jurisdiction over an interlocutory challenge to the removal or to the refusal to disqualify Mr. Hardy. Are you familiar with the cases about interlocutory appealability of orders refusing to disqualify counsel?
No, I'm not. I am familiar with, generally the law about interlocutory appeals, and there was an order issued in this case specifically refusing to disqualify Mr. Hardy and, finding that there was no attorney-client relationship. I'd be happy to separately take a look at the case law that Your Honor is referring to and file a supplement in this case.
To be clear, though, what you stated, I think in your reply brief, is that you want the court to rule that Mr. Hardy should be disqualified going forward. Did I misunderstand that request?
No, that request is correct. I was not aware that there might be a possible jurisdictional defect to this court considering that question. I mean, in my view, the probate court issued a conclusive order finding that there was no attorney-client relationship, and therefore there was no basis to consider under Rule 1.9 whether Mr. Hardy should be disqualified. I mean, this court has jurisdiction over this appeal regarding the question of heirship, and the disqualification issue was tied up with that. And so we're here today, certainly on an appealable order. I don't know if that is enough to make the order regarding disqualification ripe for review yet. But I guess if the court's not able to consider the question now, then I don't know how. It seems like the question can only be raised at a point where his further representation, if it's improper, can't really be rectified going forward.
Well, again, my understanding of the general law is, and courts were divided about this, and ultimately the Supreme Court and this court have weighed in, but, and there are reasonable arguments on both sides. But I think my understanding of the general idea is if you're at the beginning of a lawsuit and party A says, my opponent's lawyer should be disqualified for conflict of interest or other kinds of reasons, and the trial judge says, sorry, no, I'm not going to disqualify, that's not treated as interlocutorily appealable, that order, in the absence of a final order, final resolution. And instead it has to be raised as any other claim of error might be once there's a final judgment. And then you'd have to go back and see whether there was, an error that warranted relief. But can I ask you one, you said, this is getting to the merits of the disqualification issue. You said disqualified under Rule 1.9. And one of the arguments your opponent makes is, paraphrasing, I think, that Rule 1.9 is an ethical rule. It may tell you whether Mr. Hardy is violating the ethical rules. Let's say the trial judge is wrong, and in fact, there was prior representation, and in fact, the current representation is inconsistent with the requirements of Rule 1.9. your opponent, I think, is suggesting the following, which is, well, that's an ethical issue, and that might mean that Mr. Hardy will need to answer to the disciplinary authorities and ultimately to the court in the disciplinary proceedings. But that doesn't necessarily translate immediately into disqualification. And disqualification is a somewhat different additional set of issues about whether whatever ethical issue is arising entitles your client to the relief of disqualification. Do you agree that those things are different? And if you do think they're different, what's your argument about why there was not only an ethical violation here, and perhaps ongoing one, but also something that warrants or requires entitles your client to disqualification?
I agree that those are two separate questions. Whether there's a violation of Rule 1.9 in the case law has not always automatically translated into disqualification of the attorney. But in this case, the court really didn't consider any of the other sort of factors that a court would look at to determine whether to disqualify an attorney, because the court simply found that there was no attorney-client relationship. And I can talk about, I think that specific ruling was wrong under this court's decision in the In Re Fay case, which found an attorney-client relationship on the basis of sort of the same dispositive facts in this case, that Mr. Hardy filed a petition with the probate court, identifying himself as counsel. I would suggest in this case, because that was the cornerstone of the probate court's ruling, and it didn't really consider any of the other factors that go towards disqualification, I would urge this court to reverse that ruling regarding attorney-client privilege and then remand the issue of disqualification back to the probate court to decide, in light of the fact that there was an attorney-client relationship, should Mr. Hardy be disqualified on the basis of factors that the probate court never considered in the first instance in this case.
One thing I find, I should flag for you that it looks like our clock is not functioning correctly, and it isn't even appearing on the screen right now. You're around 10 minutes into your argument, so I just wanted to flag that for you. I'll let you know as time proceeds, but apologies for that technical glitch.
Yes, and I should have requested 3 minutes for rebuttal at the beginning, and I'm sorry that I forgot to make that request.
All good. We'll be happy to give you some time to rebuttal. One I find puzzling. I mean, I take a number of the points you're making, but I guess I at times I start thinking that maybe the answer to whether there is an attorney-client privilege could depend in some of the cases, somewhat like this, on for what purpose you're asking. And I certainly think it would be very hard for Mr. Hardy to deny that he was, acting as the attorney for your client. He's filing documents in which he represents himself that way, and the court is issuing orders, and then there's an order granting his or discussing his withdrawal. And so on the other hand, if the issue is from your client's perspective, should your let's say someone was trying to hold your client responsible for things that Mr. Hardy did. The connections between your client and Mr. Hardy were pretty tenuous in some ways. And I kind of wonder, the hypothetical I had in mind is, let's say that I've never met you and I go into court, and I'm an attorney, and I go into court and I file a motion on your behalf. And, so I'm really not your lawyer as it relates to you. But if I was later trying to say I had an attorney-client relationship with you and the ethical rules relating to that didn't apply, I might have a hard time. And the reason I draw that distinction is because if you're flipping over to disqualification, if your client's connections to Mr. Hardy were pretty minimal, and let's say there weren't confidential communications or privileged information passed along, which hasn't yet been proven, or even as far as I've been seen alleged, then it isn't so obvious to me why your client had the kind of attorney-client relationship with Mr. Hardy that would require disqualification. So I'm interested in your thoughts on that.
I appreciate those points, Your Honor. And, there wasn't an opportunity for this issue to be briefed before the probate court. It wasn't explored. The probate court didn't make findings of that nature. I will point out, I think one aspect of Mr. Hardy's role in this case that was prejudicial to my client is that Ms. Johnson Butler, this issue of the question of the propriety of the marriage, she learned about that fact. She testified that she learned about that in 2007, right after her mother passed passed away. She gained that information at the funeral. And then she decided not to do anything with that information until 2021, when she had a falling out with my client. Under the rules regarding the statute of limitations for challenging heirship, her claim really should have been time barred. And if Mr. Hardy was also acting in my client's best interests, there should have been advice. There should have been advice given about the fact that her challenge to his status as an heir was time barred. That challenge was never made. That advice was never given. Mr. Jenkins did retain another lawyer who didn't raise that claim. But I point this out that there were, Mr. Jenkins he has quite a low level of education. He cannot read. He was depending very heavily on Miss Johnson Butler to sort of assist him and advocate for him, and placed his entire trust in her. And then she retained Mr. Hardy, and he essentially switched sides in this case. And the relief that he asked for was not just that he, let's bring up this essentially time barred claim about his status as the heir, but he also requested that Mr. Jenkins be evicted from the home, that a restraining order be entered against him, and that actually he be referred for criminal prosecution as a bigamist. While the probate court didn't explore and arguments were not made regarding whether attorney-client confidences were shared and whether there was a violation, there were certainly sort of broader harms and sort of prejudices to Mr. Jenkins, who was a particularly vulnerable client in this case.
Why couldn't another attorney have just brought those same claims or requested the same things? What was special about him having represented your client before that impacted those things?
I'm sorry, I missed the question. If you could repeat it.
Why couldn't I'm trying to figure out why any of those things you said that he did, aside from it's very clear to me the idea that he should have advised his client that this should be time barred and a couple of the earlier on things, but the aggressive legal tactics I'll categorize them as that you described afterwards. Why wouldn't another attorney have just done that? Where's the unique harm here based on Hardy having a potential attorney-client relationship with your client to start with?
Rule 1.9 is so clear that, a lawyer, if you have previously represented a client in a matter and then there is a falling out of this nature, that you can't take a position against a former client. And I guess, maybe this goes down to the ethical violation, but the degree, this was not just a sort of, I used to represent the both of you, and now I'm just sort of helping Tracy. This was sort of, turning around and almost attacking a former client, not just sort of shifting loyalties to one client over another.
Rule 1.9 seems to require an analysis of whether Mr. Hardy and Mr. Jenkins ended up being adverse to one another. But our ruling in the Derrickson case from back in 1988, I believe, seems to suggest that if there was an attorney-client relationship and the matter is substantially related to the matter in which the lawyer represented the client, that there's an irrebuttable presumption that there were confidences exchanged and the like. So I'm not even sure we'd have to get there. So I guess what I want to ask you is there any argument here that the matter in which Mr. Hardy represented your client, which began, I guess, as a petition to reopen probate and to appoint Mr. Jenkins as the personal representative, any argument that that was not substantially related to what has transpired later in the case? It's easy to see how they're related, but substantially related within the meaning of our case law. Is there any argument that they were not substantially related?
No, I don't think there is. If I understand your question, you're asking whether this is the same or substantially related matter? Right. This was Mr. Hardy, he filed the petition to reopen probate. Right. And then filed a further petition in this same docket, in this same matter, seeking to have Mr. Jenkins removed as personal representative, removed as an heir, asking for all of that other relief. I think it would be very hard to make the case that this is not the same matter where he started out as representing both parties and assisting Mr. Jenkins, and then shifted his representation solely to Ms. Johnson Butler.
Well, you're over time. I'll give you a minute or two to wrap up if you'd like, and then we will give you your 3 minutes in rebuttal.
I'll save the rest of my time for rebuttal. Thank you.
All right, thank you. We'll hear from Mr. Leo.
Thank you, Your Honors. Good morning, Jonathan Leo, on behalf of Appellee, Ms. Tracy Johnson Butler. I first want to discuss the issue of common law marriage. The appellant rests their almost entire case on the case of Matthews v. Britain. However, that ignores two other cases involving common law marriage that specifically refer to the fact that a common law marriage requires agreement by parties legally capable of entering into a marriage relationship. And that's in United States Fidelity Guarantee Company v. Britain, 269, which is cited in my brief, as well as in Coates v. Watts, which 1980 case. And in that, or 1993 case, in that, Your Honors, it's clear that the parties have to be legally capable of expressing the mutual agreement to enter into a marriage for it to be valid under common law. And in this case, there was no testimony that this occurred after Mr. Jenkins' divorce in 1997. So
what makes you think that the phrase legally capable means after the impediment is removed? Because that almost gets us into some circular reasoning here. Matthews tells us that Matthews, and also the case of Taylor, I think, this court's case, tells us that whether or not the parties knew of the impediment, once the impediment is removed, if there was an expression of intent to be married, there's a common law marriage. So if the impediment relates to ability to enter into an agreement, into a lawful agreement, it seems to me it undercuts the holding of those cases, doesn't it?
No, Your Honor, because I believe it then says, because those cases, they state that, but then they also refer that they and cohabitating as man and wife after the fact. And the phrase man and wife is not just simply cohabitating, it's as man and wife. And that implies that there's some sort of agreement, which and again, Matthews directly cites to the Fidelity Guarantee Company, because it just happened 2 or 3 years prior. And it essentially refers to it as being, good case law.
Well, can I ask you, just to make sure I understand, after the impediment was lifted in this case, I thought it was undisputed that Mr. Jenkins and Mrs. Jenkins both held themselves out as husband and wife. And so in what sense was that not itself like them each agreeing, yes, we are husband and wife? And you mean there has to be like have to have a sit down where they enter into a new contract of common law marriage? Is that what you have in mind, or?
Your Honor, I'd refer to Coates v. Watts in the footnote on that page. It discusses how it states that if one party was unaware that the other was married, it renders any contention that there was a valid present agreement to marry dubious, to say the least. That's in the footnote 1 in that case. And I think that it's necessary. It may not have to be a formal sit down, but they have to come to some sort of understanding, and it has to be mutual and expressed.
Well, but I mean, again, the word agree is somewhat ambiguous. That's what I'm getting at. I mean, if I put two people in two different rooms and I say to them, is the person in the other room your husband? And the answer is yes. And then they go to the other room. Is the person in the other room your spouse? And they both say yes. So you could say they agreed. They each answered this question in the same way. But you think they have to be sitting in the same room for there to have been an agreement of the kind that's required? Or
Well, they have to come to an understanding, and it should be based on they have to come to an understanding about their relationship. And I believe the case law, it may be slightly confusing, but that it seems to me from the case law that that they cannot have done it prior to the impediment being removed, or else it makes the phrase void ab initio useless.
how do you square?
the sentence in Matthews about the fidelity case says that the holding of that case is that if there was no agreement to be married either before or after the removal of an impediment, no marriage can take place. So Matthews explicitly relies on that principle from fidelity, that the agreement to be married can come before the removal of the impediment.
I get that. I understand that, Your Honor. But if you read fidelity, it seems to me that it's stating that it has to be after when they are legally capable of entering into the marriage, and they're not legally capable of entering into the marriage if he was already married to someone else. And again,
and how do you square your view of the relationship between Matthews and fidelity with the DC Circuit's earlier decision in Thomas, the 107 F second case, which also seems to state more as a general, pretty clearly a general rule, which is if there, if after an impediment is lifted, the spouses hold themselves out as married, that for a long enough period of time, that will give rise to a valid marriage. And it doesn't matter whether one or both of them doesn't really know about the underlying impediment. So what's your view about how that fits into the picture?
Yes, Your Honor. I think, again, it's the phrase cohabitating as man and holding yourself out as man and wife. And I think that entails some sort of understanding to be married.
Well, how could that be if when the express wording in that case is it doesn't matter whether one of them or both of them knew about the impediment? Because your point, it seems like your point really isn't so much was there an agreement after the impediment was listed to be spouses, because they were every day living out that agreement. Your point seems to be we need reaffirmation based on awareness of the impediment that has now been lifted. So the spouse, if one of the spouses didn't know about the impediment, you need to have proof that that spouse became aware of the impediment and nonetheless continued to agree to hold himself or herself out as married. Am I right? Is that a right way of understanding your point, or am I missing something?
Your Honor, I think that would be the clearest way to satisfy the common law test in this jurisdiction. And I think that's what the lower court was getting at in its opinion.
Help me understand what the base minimum would be for you for them to satisfy it. It strikes me as a principle that the very idea of common law marriage is for us to not require legal sophistication of individuals, not going through a very formalized process. What level, you've talked in some good generalities, but where is the brightest line you can get for what minimally qualifies after the impediment?
So I would say that if she was aware of the divorce and still agreed that they should be man and wife together, then that would satisfy the test under the jurisdiction.
And we have some, in addition to the fidelity case that you mentioned, and then you mentioned Coates, we also have some other cases, there are cases like Lee, where we seem to have read Matthews, Britton is in both of the two, Matthews, and the earlier case as pretty much just establishing a flat rule. If there are folks who believe themselves to be married, they're wrong because there's an impediment. The impediment is lifted. Thereafter, they live together as spouses, then the marriage is valid. And you think those cases are incorrect, invalid, because you think sort of Britain governs rather than those cases, or what's your
Honor? So essentially, those cases have sort of a rote explanation and repetition of the statement, but they keep saying hold themselves out as husband and wife. And so it's not simply just cohabitation. There's the husband and wife, a spousal aspect to it that is not really explored. And Coates v. Watts does get into that, what exactly that refers to in terms of, what you do together and when there was an agreement regarding it. Again,
I guess I'm losing you a little bit. Are you saying that if we look at what happened here after the impediment was lifted, it's not correctly described as the Jenkinses holding themselves out as husband and wife?
I don't believe so, Your Honor. Under common law marriage, I don't believe so.
Well, I mean, if in ordinary language, they're referring to each other as husband and wife and acting as their husband and wife. So there may be a problem. They may not have validly done so, but just in terms of how you would ordinarily speak, it seems like they are holding themselves out as husband and wife after the impediment is lifted. But you think there's some technical meaning to those terms, or do you think that actually they really weren't in ordinary language holding themselves out as husband and wife?
Your Honor, I'm referring to the fact that this jurisdiction requires an express mutual agreement at the present tense.
Well, I get that legal point. I mean, I understand the legal argument you're making about what the law requires, but you're saying that we have some opinions that seem to state as a rule that if after an impediment is listed, folks hold themselves out as married, their marriage is valid if they hold themselves out as husband and wife. And I thought you were saying that those cases should be understood because by interpreting the phrase hold yourself out as husband and wife in some special way. And I'm just trying to follow that because it seems like that isn't kind of an ordinary way of understanding that language. And I'm trying to understand whether you actually think it is the ordinary way of understanding the language, or whether what you're saying is that sounds like one thing, but if you understand our cases, really there's an additional requirement that isn't very clearly captured by that.
Yes, Your Honor, that's what I'm saying, the latter point, because I believe it has to do with the express agreement after the fact. And
Judge Howard, I think, was getting at this, but could you just, in a nutshell, could you explain why you think that should be the rule? Like, why is that good policy? So why should we, as a matter of policy, conclude that as a matter of law, what happened here was not a valid marriage?
Why? Because it could be a marriage was induced by fraud if she didn't know about that, and we certainly don't want to encourage fraudulent marriages. Or let's not forget that the reason he was able to do this was he used a different name on 2 different marriage licenses within 2 or 3 years of each other in different jurisdictions. It's evading the law, and that is certainly not in the public interest for that reason. It's not as if they just told people that they were husband and wife. They went down to a courthouse and he committed fraud by lying on his marriage application. We should not encourage that behavior. And again, it could be seen as taking advantage of a woman who was unaware of this, and perhaps things would have been different, and we should not encourage such behavior, Your Honor.
Does the record support a finding, or was there a finding that Mr. Jenkins' reason for using a different name on his application for a license to marry Mrs. Jenkins, was a fraudulent intent? There are references to him having a different name before, but what was there evidence of what his intent was in using the different name, or did the trial court make a finding about that?
The trial court, I believe, made.
I think the court mentioned the fact that he used a different name for sure.
Well, so the trial court discredited most of his testimony based off his history of misrepresentations and different conflicting testimony to the court. He did say that the lower court made a finding that he made a material false statement on the application for marriage license, and found that he knew that he knew it was false because he knew that he had been married previously. So he made the court found that he made a false statement that he, on his marriage application, that he was not married at the time.
Back on your answer to my policy question, I just wonder, in Thomas, the court expressly addressed this question of what the better policy is. And it acknowledged kind of the line of thinking that you have identified. And then it said the general rule has sometimes been applied, even though one or both of the parties knew of the impediment, which is, again, as the trial court found the facts, the case here. And then the court says, since marriage is preferable to concubinage, I'm not sure that's the right way of pronouncing that word, this result seems socially sound. It's also logical. You can assume that people intended to be married as soon as they lawfully could be. And so the Thomas opinion seems to have disagreed with your view about what the better policy is. And so it leaves open the question of whether we're free to adopt instead the policy that you're advocating and the rule of law that you're advocating.
Well, Your Honor, that's a 1939 opinion. And I believe the social changes in terms of married versus unmarried cohabitation have certainly changed a lot. So the policy promoting that people who live together should be seen as married, I don't believe that is relevant, timely in the current society. So that as a goal of public policy that people living together should be married, I don't think that's seen in quite the same way as it would have been in 1939, which was the policy it was promoting at the time.
But what about when, as in this case, literally everyone who testified, and it seems like the general public and community as a whole, viewed the two as married?
Again, it was obtained. It was obtained through fraud. That's what I would say.
You seem to be suggesting in your exchange with Judge McLeese earlier that there was no indication that the Jenkinses held themselves out as husband and wife after the impediment was removed. And let's assume for the moment that Mrs. Jenkins did not ever know of the impediment. Was there any testimony to the effect that the couple did not hold themselves out as husband and wife? I mean, my recollection is that even your client, in describing what she knew of their relationship and describing how she believed her mother didn't know about the earlier marriage or the divorce, seemed to be suggesting that they very much did hold themselves out as a married couple.
Your Honor,
are you suggesting to the contrary? That there's evidence to the contrary?
No, Your Honor, I was referring to that phrase and meaning that they had an express agreement after the fact to be husband and wife.
Right. I understand your point about the agreement, but I thought you were suggesting that in terms of other indications of how they held themselves out.
No, Your Honor, that was not my intent. It was simply my explanation of what that phrase, holding yourselves out as husband and wife, meant in the legal context of these cases, of this line of cases.
Ms. Ugolini filled us in on some more recent developments in the case with respect to Mr. Hardy. Do you have anything to add about that in terms of what issues we should regard as being before us or what issues we should address?
Your Honor.
To put it bluntly, is Mr. Hardy still involved in this case? To your knowledge?
To my knowledge, he's still involved in the case. Yes, I believe he appeared at the status hearing that was recently held. I was not at the status hearing, but I believe he's still involved in the case.
You're over time, but do you want to take a minute to try to address the question of whether there was prior representation? Some of the questions that were raised with your opponent focused on at least some of the circumstances here that I think you would acknowledge at least tend to provide at least some support for the idea that there was attorney-client relationship, like the filing of a pleading that represents the existence of that relationship.
Yes, Your Honor, but I would say that, again, the issue before the court would be disqualification, which would be viewed as whether there is a conflict of interest that undermines the court's confidence in the vigor of the attorney's representation of his client, or where the attorney was in a position to use confidential or privileged information against a former client or against another party. And
well, I mean, that is a question. It wasn't the one I was focused on initially, which is whether there was an attorney-client relationship, which the trial court said there was not. Do you defend the trial court's ruling that in fact there was no attorney-client relationship between Mr. Hardy and Mr. Jenkins?
Yes.
And that seems like a somewhat tough hill to climb. If Mr. Hardy filed a pleading in which was characterized and treated by everyone as on behalf of Mr. Jenkins, not solely Mr. Jenkins, but Mr. Jenkins.
I understand, Your Honor, but I'll say, so when he submitted that, the first petition had Tracy Johnson Butler's name on it as who he was filing on behalf of, and the clerk refused to accept it. So they agreed to put his Mr. Jenkins' name on the petition, but at all times he was.
Can I just ask you? You said they agreed. In that sentence, in your mind, who's they?
Well, I guess Mr. Jenkins and Miss Tracy Johnson Butler, I assume. And again, I was not involved at that time, so I don't know exactly, and I may be mischaracterizing what happened, but the record is clear that he did file it using Mr. Jenkins' name, but the testimony from all involved was that Miss Tracy Johnson Butler was the only person that Mr. Hardy dealt with.
Well, there was certainly some evidence that Mr. Jenkins dealt with Mr. Hardy in the sense that he complained about the case not moving fast enough. He terminated him, sent him a termination letter when he came to the view that Mr. Hardy was not adequately representing his interests. So there were dealings between them, were there not?
I guess they interacted once or twice, but again, nothing privileged. That there's been no allegation of any privileged information being obtained or used in this case. And again, I believe the issue is disqualification, and that has not been shown that the trial court abused its discretion in not disqualifying him.
Well, if the trial court didn't disqualify because the trial court incorrectly thought there was no attorney-client privilege, then that mistake of law would be viewed as an abuse of discretion requiring remand if the matter was properly in front of us. Because the trial court didn't, in the alternative, go on and say, well, even if there was an attorney-client relationship, there would be no need for disqualification because of some of the points you're making now, unless I'm misrecollecting.
And that's correct, Your Honor.
I'm looking at the language.
I believe that's correct.
I'm looking at the language in our Derrickson v. Derrickson case, which says that if a party seeking disqualification carries its burden of persuading the fact finder that the two matters handled by the same counsel are substantially related, there's an irrebuttable presumption that counsel received information during the first representation that is relevant to the second. So I think we don't get to argue about whether or not there was confidential information exchanged if the attorney-client relationship and the substantially related criteria are satisfied. Do you have an argument that the matter on, let's assume for the moment that there was an attorney-client relationship. Is there an argument that the matter on which Mr. Hardy represented Mr. Jenkins was not substantially related to the matters that came thereafter that resulted in Mr. Jenkins being disqualified as an heir?
Yes, we can. The opening of an estate can be seen as more of a transactional matter with the court, and the argument over who should be considered an heir is a separate matter. And while they are somewhat related, I believe you can argue that they are not substantially related, as again, the attorney petitioning to open up an estate, that it's a lot different. That happens tons of times a year. And it's very much different than an argument over who is the proper heir in a common law and whether a common law marriage was valid. Those can be seen as separate issues.
Thank you, counsel. I think your time is up, so we will hear now from Ms. Ugolini in rebuttal.
Thank you. I just would like to respond to a couple points that I heard made regarding the common law marriage issue. On this question of whether you have to be legally capable of entering the agreement, this point about the footnote in Coates and the United States Fidelity case. The Matthews case clarified the Fidelity case and rejected the notion that Fidelity had overruled Thomas versus Murphy. I think the Coates panel was just unaware of the Matthews precedent. Certainly there was no mention of Matthews in the case. Also, that footnote in Coates is dicta, because ultimately there was no proof of an agreement to be married at any time. And Matthews has certainly been reaffirmed by this court in Cooper v. Lish, Taylor versus Taylor. And in those cases, the rule did matter. The rule that the marriage can become a valid common law marriage after the impediment is removed, it mattered in those cases because in both of those cases, it involved a couple that had gotten married before a prior divorce was final. On the point made about fraud and whether Mr. Jenkins induced Mrs. Jenkins to get married under fraudulent circumstances, we addressed this on page 6 of our reply brief. There was no evidence whatsoever in this case of fraud. The only testimony at all about the name was Mr. Jenkins was asked during the trial, one certificate had Jenkins, one had Mackenzie. This is at JA 179. And he just responded, one name is his stepfather's name and the other is his own father's name. There was no further questioning about why different names were used. That testimony was simply not developed at all. And of course, it would have been Ms. Johnson Butler's burden to show fraud by clear and convincing evidence. That comes from the In Re Estate of Nethkin case that we cited in our reply brief. So there's simply no evidence in the record to support an argument that Mr. Jenkins fraudulently induced this marriage. And in fact, the testimony was also uniform that Mrs. Jenkins was aware of the prior relationship. She met Ms. Carr, she met the daughters, and Ms. Johnson Butler testified that she grew up playing with the daughters and she referred to them throughout her testimony as her sisters. So certainly the prior relationship was no secret. In terms of, policy and whether it's time to sort of overrule some of these older cases, this court actually addressed that in the East case, which we also cited in our brief. In the East case, I think one of the parties made an argument that common law marriage is just a bad idea and it's bad policy. And this court said, even if that's so, one panel can't overrule 57 years of precedent. The court would need to go en banc to do that. And I think that that same principle applies in this case to the Thomas v. Murphy intent and knowledge factors. And just one quick response to the notion here that petition to reopen probate is a separate matter from the petition to remove Mr. Jenkins as heir. I mean, these two things were literally decided in the same proceeding under the same docket number by the same judge. I think it's very hard to argue that they are not substantially related, if not the same and identical matter. Unless the court has any further questions, we would just ask that the judgment of the probate court be reversed.
Thank you to both counsel for your arguments today and for the briefs, and we will take the case under advisement.
Thank you, Your Honor.
You're
you.
free to exit the virtual courtroom.
Thanks.
Thank you. It looks like we're ready to proceed on the second of the two cases on this morning's calendar. That case is Kenney v. Kenney. It is case number 22 FM 129, and we'll hear first from Mr. Klepper.
Thank you, Judge McLeese, and may it please the court. Stephen Klepper for the appellant, Kathleen Kenney, and I'd like to reserve 2 minutes for rebuttal. So after briefing closed, the custody trial happened in August, and I think we can narrow the inquiry somewhat here because we are narrowing the relief that we're seeking in this appeal. Putting the family through another custody trial is not in the girl's interest, so we're not challenging the exercise of jurisdiction. And we don't need to get into many of the tough questions that I was hearing in the last argument about pending jurisdiction over other rulings. What we're here to challenge today is the temporary custody order. Rulings from custody trials can take 9 to 18 months. In the meantime, the trial court has refused to revisit the temporary custody order entered as a result of its erroneous finding of parental kidnapping. And 11 months ago, a perceived emergency led to a rush to judgment that did not consider the girl's best interests under the statutory factors, and that has controlled their lives for 11 months. It has the effect of an injunction, and it is appealable under cases like in re SCM. The erroneous findings about parental kidnapping led to an early snap judgment about my client and the equities that have affected every step of this case. It is like a railroad switch was flipped. This case went down a different track once the trial judge decided very early on this was parental kidnapping and said, I readily find parental kidnapping. And before I get to the parental kidnapping argument, I'd like to say the relief that we're seeking. And the relief that we're seeking is what I would call a hard remand, not just what family lawyers jokingly call homework assignment for the trial judge to explain the reasoning better. Something that makes clear that there was a serious legal error that affected the trial judge's first impression of the parties in the case. And it's not enough to say, we're putting that behind us. This is how it's been going for 11 months. There needs to be a clear signal that the trial judge from the jump made a serious error that requires a fundamental rethinking of this case to center the girl's interests under the statutory factors. And I would further like to say, another thing happened after the briefing closed, which is I learned about the Cho versus Davis argument that happened in this court before Judges McLeese, Howard, and Deal back in May. And from that argument, what I was certainly hearing was that the court would like some broader statutory interpretation guidance beyond, well, whatever parental kidnapping it is, it isn't this case. And so I'm here prepared to articulate a workable statutory standard and to back that up and to show how that does not, this was not parental kidnapping under that standard.
Could I ask you just for me, I mean, the heading of the, I guess the subchapter at issue here is parental kidnapping.
Yeah.
But the particular provision that is at issue is essentially parental concealment. And so to me, I always, what happened here doesn't feel much like kidnapping in a lot of ways. But the real inquiry in terms of what the statute tells us to look at least first, most directly, is whether this was parental concealment. And so you're going to, you say, tell us what your definition of, I guess, concealment is, or intentional concealment.
That is exactly what I'm going to do, Your Honor. And I'm here to address what concealment means and what intentionally means. So concealment, we need to understand this was enacted in 1986. And once we get into the reasons I will give, we will see that this can only refer to what I will call milk carton acts, taking the child under circumstances where the other parent does not even know where to begin looking. which police department to call, where to try to use legal process and send summonses to try to get the children to allow the court to work out the parental differences.
So if spouse A is part of marital discord, ends up using self-help and leaving with a child in common, and spouse B says, "Where is the child?" and spouse A says, "I'm not going to tell you. I'm somewhere in Chicago."
Mhm.
Your view, and then spouse B is looking for months in Chicago and never finds the child, and you would say no parental concealment.
I would say no,
because you know what police department to call.
I would say so, but in generally, I'm using that as a broad stroke, and that's where we get into intentionally, because intentionally really helps to clarify and indeed, of course, modifies concealment. Intentionally means a mens rea. Contrast it with the knowing language that appears in subsection B. Subsection B says knowledge. And what I know from first year criminal law is that means that knowledge of the consequence, recklessness of the consequence, or negligence as to consequence is not enough. This has to be a specific design to prevent the other parent from using the courts to sort out the differences between the parents. And let me now explain why. There are three ways that I get there.
Can I just make sure? So that sounds like if you're not so much worried about milk cartons and police departments and more about what court could you use, if parent A, again, in the hypothetical that I was describing, after some marital discord, leaves with a child in common, and parent B says, "Where's the child?" and parent A says, "I'm not going to tell you, but you know where the courthouse is. I have the child. So don't worry that I've given the child to some other person. So I'm the person, if you want to get help from a court, I'm the person who you should be suing." Is your view that doesn't violate the statute?
Correct. Now, and what I will argue is the court can set this standard lower, and this case still comes nowhere near intentional concealment. But here's what I will say: as I have looked through as best I can using all the statutory tools that I know, that this is the only judicially manageable standard that focuses the children's interest in the analysis. And I want to do that again and again. We want to focus the children's interest. So first, the City Council enacted this May 23rd, 1986. And we don't have bill file or anything like that, but we do know is that the National Center for Missing and Exploited Children was founded in 1984. And it was January 1985 that the milk carton campaign started. And that's when, lo and behold, the last place seen for most of these children was with another parent. And it changed the societal view of what kidnapping was. And this was enacted in 1986 to address a specific problem with one of the most immediate and successful awareness raising and legal campaigns of the 1980s. This was not designed for the era of mobile phones and texting. In 1986, I know my family didn't even have call waiting yet. If the line was busy, the line was busy. And I was a latchkey kid in 1986, and there were miscommunications all of the time. It was expected that there would be blocks of hours where people didn't know where each other was, particularly if there were communication problems, as would occur in a bad marriage. This was designed to protect children from a particular danger, not to center their parents' feelings or to say that unilateral removals are prohibited unless there's real-time geolocation, real-time updates about a precise location. And within that background, that's the only thing this could have meant in the 1980s. So secondly, I'd like to get to the consequences, because we know that we can read a statute and figure out the consequences, particularly within a larger statutory scheme. The consequences for the children and those for the removing parent. Because parental kidnapping creates a rebuttable presumption about the children's best interests. So it has to be something that is presumptively harmful to the children, not to the parents' feelings. And also, of course, there are the further consequences to the parent, less important for our purposes, but it is a criminal violation and under punishable and under 16-1024. But there are also severe collateral consequences. There's reputational and professional injury, particularly my client, to have a parental kidnapping finding on their record. And when you really think this through, nothing short of the inherently bad for the child act of milk carton concealment could warrant these kinds of consequences for the children and for the parent.
For me, I guess the milk carton analogy is somewhat abstract, and I'm not quite sure. I mean, that's not, we certainly couldn't write an opinion saying, here's the test. Is it milk carton concealment? So if you were going to be more concrete about words that you think, for an act to amount to concealment, leave aside for a minute intentional concealment, but for an act to amount to parental concealment, it will have to be X, and you have some form of words that you think is your workable test. I guess I would say I'd ask that it not be milk carton, because I don't see that as workable. So what's the form of words you're advocating?
I think that this came up in Cho versus Davis. The phrase that had come up in some other jurisdictions was go into hiding. What the reasonable person would have understood as the act of going into hiding.
But that sounds, that sounds different from one of your answers. The broadest answer you gave to one of my questions was, I can go into hiding and I don't violate the statute as long as I tell the other spouse it's me with whom the child is hiding.
Well, I think in response to that and what I said, and maybe I am bleeding these two a little bit, Your Honor, because I don't think you can take intentionally and conceal, like strictly diagram what each one means. Together, they have a meaning. The intentional concealment is that it has to be designed to deprive the other parent of invoking the legal process to allow the courts to sort out the differences between the parents.
And why do you think it has to be that?
Because anything short of that is going far beyond what the city council would have intended in 1986. The Cho versus Davis, and I apologize for using that as a shorthand, Judge Thompson, because you were not on that panel, but the court kept going through many, many hypotheticals, and those hypotheticals kept on coming up. Well, what about playing hide and seek? What about I'm driving and I don't know where I'm going right now, but I can't see you again until I have a chance to cool down? Like, these are real problems. And when I talk about slippery slopes, I know lawyers like to talk about slippery slopes all the time. This is a real issue with real consequences for kids. And now, so I will tell you, let me get to my third point on this, which is under the UCCJEA and Hips versus Cabrera, we know that unilateral removal is only relevant or sufficient if and when a statute says so. And that's because unilateral removals happen all the time at the time of breakup. And each parent at the time that things fall apart have a presumptive right to do what they believe is in their child's best interest. Now, in that situation, there's always a breakdown in communications. Good marriages don't fall apart like that. Marriages of the bad communication fall apart like that. And so the trial court's view would criminalize ordinary disagreements and create rebuttable presumptions about what is best for the children, and unmooring that from the concept of what is best for the children. The reason
go ahead.
No.
I'm sorry. Is it an ordinary agreement when a child or children are kept away from a parent for a week or more?
I would say that a week or more would, in fact, be. I hate giving particular days and knowing like different standards, but a week would be something within a, it's as we're getting closer. And again, I don't know the exact. I'm trying to defend what I can be the best something that's judicially manageable. But let me give you. Why don't we at this point? I do want to use this case because I think this case does. Even more clearly than in Cho versus Davis show, where parental kidnapping came into play and how it's clearly not there, because I think this case facts do answer some hypotheticals. So we're talking about January 2022, and on the 12th, we know what husband said in the motion that got all this rolling. As part of the party's argument on January 12th, Mrs. Kenney threatened that she was going to take the party's children to Chicago without Mr. Kenney's approval. Eventually, she threatened this type of parental kidnapping an additional time during the specific discussion. So the parental kidnapping was always in his mind, taking the kids back to Chicago. And we know where in Chicago. Chicago is where the parties had their family home. They didn't rent it out. That's where they were still paying for school for RK, still paying tuition to hold her spot in case this experiment of the prior few months didn't work out. Mr. Kenney always knew that this was the place that they were likely to go. And so when you center his feelings of a momentary anxiety, that is where we start to say, all right, well, can this really be concealment? And then, of course, let's look at the text messages, the key text messages from January 20th. The claim here is that it took from 3:55 to 8:55 p.m. Eastern, and then the texts are a little different because it's 2:55 to 7:55 Central, for the mother to respond to the portions of the father's texts asking where the girls were. And when he asked the first time, less than 15 minutes after he asked the first time, Mrs. Kenney said, they're with the girls are with me. I have no intention of taking them from you. And after Ms. Kenney says they're with me, there's no text, none, where he says, that's not good enough. You didn't answer my question. What he says is, this was done to hurt me. That's what he says. And then after 3 more follow-up texts, he sends no more texts and doesn't try calling again from 4:35 Eastern until the next morning. And instead he gets a steak dinner at Blue Duck Tavern, goes to sleep, and the next morning arranges to FaceTime the girls. And regarding Ms. Kenney's statement, I have no intention of taking them. It's like, well, taking them to Chicago, but let's remember, from July 2020 to July 21, father chose during the early pandemic, restricting children's travel, to live in the district and commute to Chicago on the weekends. Ms. Kenney gave birth to DK while Ms. Kenney was wearing a mask, and 5 days later, Mr. Kenney was back in the district where he preferred to build his career. And so taking the kids back to Chicago, to the family home, so that Mr. Kenney has to commute, is simply taking things back to how they had been working for the children's lives.
Can I ask you to focus, you've been focusing on the events of the 20th, but there's also the second date of alleged parental concealment.
Exactly.
Obviously, on some of the broader views you have advocated, that would fall well short of parental concealment, much less intentional parental concealment. Just in ordinary language, one could think that it seems like intentional concealment. The father is coming out and he wants to see his children. He wants to know where they are. He is going to the place where, as you are arguing in connection with the events of January 20th, he would naturally assume they would be. And one could, it seems like, infer, and I think the trial court did infer, that your client removed the children from that place and took the children to some undisclosed restaurant and said, here's a picture, I'm not, and refused to let him know where the children were, in a way that would allow him to go see them. And obviously he had his own plans that she didn't agree with, but that seems like, in kind of ordinary language, it seems like concealment. And unless we go pretty far down the road to some of the formulations you've been advocating, I'm not sure why it shouldn't normally be understood as intentional concealment. You want to see the children, I'm going to move them from where you can usually find them, not tell you where they are, and make it so you can't see them.
Well, Your Honor, I would not have made the argument I did earlier without the documents to back up to show that is not what happened here. At A142 of the record, through the legal process, mother's lawyer writes to father's lawyer, January 29th, and says, Ms. Kenney will make the children available for visitation, but will not produce them if you're there to take them. That's what that email said, through the legal process.
Well, the point you're making now is, I guess, in part, it sounds like you're hinting at a defense, but I gather you are not relying on any of the defenses in 16-1023. Is that correct?
I think there actually is some of the defenses here, but let me.
Well, let me just ask you, in terms of how you briefed it.
Yeah.
In the trial court and here, have you identified some sort of a defense as opposed to instead arguing that this didn't amount to intentional concealment?
Well, this is not concealment, because
I'm just asking before you.
No, I would say that, if this were to be vacated and sent back down on a legal standard, we might get into the defenses. But the way that this was, ruled on summarily, and there wasn't briefing in the lower court because
There was in this court, and
there was in this court.
Right.
So,
is your point that the idea, I'm just trying to see if I gather the gist of your argument. And is it something like this?
And
look, he was willing, as the communications between, she was willing, as the communications between the lawyers indicated, to let him see the children and make them available to him, and let him, not hide them. They weren't going into hiding.
Mm-hmm.
And she was willing to make them available, but she had conditions about how she was going to do it. And she was concerned that he was going to do things she didn't want to do. And so it was kind of conditional availability. It's like, I'm willing to make them available in certain ways, in certain times, in certain circumstances. I'm not going into hiding with them, but that doesn't mean I will make, let you know at all times exactly where they are and make them available to you at all times. And your view is that frame of that sort of approach should not be treated as either concealment or at least intentional concealment under your view. Is that the idea?
That is exactly right, Your Honor. And at 829 of the appendix, father, acting outside the legal process after the lawyers spoke, said, I'm flying out to Chicago. I have 3 return tickets. I'm taking the girls with me. You can come with me or not.
Well, you say acting outside the legal process, that I thought your view about what your client did initially was that that's totally fine inside that's what the legal process, I mean, that's within the legal regime that governed them at the time.
Well, at that time, Your Honor, there had been, what had happened in the meantime was that there were 2 different child custody proceedings started. And what my client consistently said in the text and the emails was, we're going to let the court sort this out. And she said, in the meantime, you can see the kids, just like he'd always commuted back to see the kids on the weekends. You can see them, but under the circumstances, we're going to take them.
But make sure, though, is it your view that if the father had somehow been able to implement his plan on that date, let's say that he had happened to arrive as the mother was leaving with the children, and the children had not, let's say there was no physical altercation or anything like that, but he had been able to say, hey, kids, come on in the car, and then they'd driven off. Is it your claim that that would have been unlawful in some way for him to have done, or would have amounted to, or is it your view that would have been unlawful, or is it your view that would have been within the self-help regime that was operative at the time?
I think that there was a substantial risk that it would have been lawful within a self-help regime, and that, yes, this was saying, I don't have the obligation to be home at this particular moment when you have said you're going to be there for the express purpose of taking the girls. And I want to look at the texts, because we've gone the email here, but if you look at the texts, this is page A270. He says, I'm in Chicago, as you know, I'm on the way to our jointly owned condo to see my children. I will be there in about 30 minutes. And his next text says, I ask that you keep things civil for the kids and that you do not physically approach me. Now, what I can proffer is that as it went down to trial, that the facts got even worse for father in terms of what he was expecting. But in terms of just what we're talking now, he says, Katie, I have every right to know where my children are. Please call me. And Katie, Ms. Kenny's response is, David, the attorneys need to work this out. Please contact yours. I've been in touch with all of mine. Everyone is safe, but we need the attorneys to work this out. Please call your attorney. That's what she says, because he was acting outside the attorneys. And she then responds, what he then says is, we both have equal access to the kids. You have denied me the last 11 days. That's not right or fair to me or the kids. And here's what he says. Please let me know where the kids are. I'm not going to show up anywhere. I'm at our condo. I just need to know where my kids are. If they're safe/well, you can send me pictures if you'd like. So he has said right then and there that he wants to know the kids are safe. And he says, where the kids are, but he still says, I'm not showing up anywhere. She is not actually depriving him of access in that moment. And then when she responds with the picture on A272, they are safe. I want you to see and be with the kids. We both have that right. I completely agree. But we need the attorneys to figure this out for both of us so everyone feels safe. And his response to that is, please make sure the girl's available via FaceTime this evening. Let's plan on 5 Central. And she sounds says, sounds good, we'll do. Like, in terms of, is this concealment? What this is showing is the real dangers, because, what we have in the era of cell phones and texts is, we have a record that can, here be very clear. We have two very, well-educated people who are talking. There is a record that's created absolutely as to what their intentions were. But when we start imposing criminal penalties and civil, it is a civil presumption that this has rendered not in the kid's best interest to be with that parent who did it. And then it has to be overcome instead of the ordinary analysis. Those consequences are so great that is precisely why I'm setting the standard very high. Now,
let me
can set the
back you up
standard
for
high.
a second from where you are right there. I was interested. I was listening to your characterization of things and the communication between the attorneys and the parents here. And one thing I missed on that, I remember from the record, was that it was, I'm not going to let you take these kids. I'm not going to let you see them for the purpose of taking them. And we're not going to see them until we get an order in Illinois. I didn't hear that order in Illinois. Does that change the way we should look at this at all? Can we see that as a way of potentially trying to get a legal advantage in this case by keeping him away from the kids until he agrees to some sort of court action in Illinois that could be the basis of jurisdiction and defeat his attempt to have jurisdiction in DC?
That is not how it should be viewed, Your Honor. I should also tell you, I've litigated forum battles with first to file, usually with insurance companies, but usually the desire to have a particular forum is not considered bad. It is something much greater. Whether or not the children were in Chicago or in Washington, D.C. did not affect the jurisdiction of either court to determine what was in the children's best interests. Where they happened to be during that time was not and should not have been relevant. And in fact, when the District of Columbia Superior Court entered an order saying bring them to the district, she did it. This was not changing anything in that general sense. And I believe I'm now missing part of your question that I've momentarily forgotten.
Well, my concern was if getting an order in the Illinois court was part of the requirement, and if he consented to that, could it be viewed as him waiving any potential challenge or waiving a challenge to that court's jurisdiction later on?
That's what parties negotiate all the time. What I do all the time in first to file disputes is to say, all right, well, this is not a waiver of this particular point. But when we're talking about the timing, let's remember there was a hearing on the morning of February 1st in the Cook County Court and said this will be memorialized. And then in the time between that hearing and that order being entered, which said, well, now this is how things are going to proceed. That is when Judge Pittman said, no, I'm holding a hearing and I'm deciding. And then on the spot, he says, I have serious concerns about parental kidnapping. And I'm calling the Cook County judge and I'm going to exercise home state jurisdiction here.
Can I ask you a question? Just again, I'm trying to see what your positions are and where a workable rule might be. So imagine the following hypothetical. Imagine again, marital relationship is breaking down and spouse A takes a child in common and leaves a note which says the following. I'm taking the child. I understand that you have a legal right to see the child, but I'm not going to tell you where I'm going. And I'm going to keep the child with me at all times. The child will be safe until you get an order that entitles you to some sort of legal right to see the child. I'm going to keep the child with me, and you're not going to have access to the child. But go to court, get an order. We'll work it out. The lawyers will work it out. Go to court. But it's from the moment I take the child until you get a court order. I'm neither going to let you see the child, nor am I going to tell you where I am. In your view, is that parental concealment in violation of the statute, or is that lawful under the statute?
I think that is getting close, but I think it still falls short. And the reason is the parent has expressed a desire to comply with legal processes. Any court exercising its jurisdiction would find that would be consent to even like publication notice or something like that of where here you can enter that order. You can say, here you go, here's the order. Okay, here I am. And that does, I don't think that that is concealment, Your Honor. And I think that when we start going lower than that, this is like a parabola in, what I remember of high school math, you approach, but you never quite touch, that we can get closer and closer and closer. But until you get to that intentional concealment, there's a risk of putting a child on a milk carton, that I think we are deviating from what the city council's manifest intent was from the circumstances, from the 1980s, the awareness raising campaign. This is going into hiding. And this has to be, we have to draw some lines, Your Honor, because, as Cho versus Davis in this case show, this is a recurring issue, and the city council didn't give us much guidance. And if this court says this is how we interpret it, because there are so many potential bad consequences, and it's a risk-benefit analysis, right? That there can be problems. That is for the city council to decide for the wide range of cases. And if this court gets it wrong, the city council can introduce a bill and they can really tighten this up and give greater guidance. And I just think that given the incredible consequences there were for the parties in this case, that this court has to say, yes, there is a line here. And I think the way that I want to show this in final is to show just, the Superior Court short-circuited the statutory factors. The essential finding was that there was parental kidnapping, and from there, both parents are good parents, and treated it as a low-stakes affair. Because both parents are good parents, there'll be no harm to them either way, whichever way I do in the meantime, who has primary physical custody. And the physical custody finding didn't flow from the factual findings. It was unmoored from the statutory factors. And while we're not challenging the forum state ruling in terms of a remedy, the forum state ruling, it was flat out contrary to Hips. It didn't focus on the statutory factors because there was no finding that even an intentional concealment was violence to the children. And so when you look at the factors, the actual enumerated statutory factors, the relationship with the family and other persons, all back in Chicago, that they are, they have the support network of family, they've got the nanny who still looked after them there.
Are you not talking about the forum factors or the best interest?
No, I'm sorry. I'm now putting them in the child custody factors.
Okay.
I'm sorry. I did not do a good transition to that. The prior involvement in the kids' lives. There's a long history of the kids being away from the father, and it happens to be by his choice, with no history of being away from the mother for more than 2 nights ever. The status quo for the children is relationship with their parents, not their physical location as in and of itself, because that can lead to the kind of, look, I raised my kids in Baltimore and my sister raises her kids in Chicago, and neither would ever trade places. There's a fundamental view, like wherever we live, well, we raise our families here because we think it's better. So status quo has to be about the relationship with the parents. DK was 16 months old at the time this happened, barely weaned. She had been breastfed until just a few months before that. That was the relationship. Primary custody then given to the father in a way that, if the trial judge had said primary custody is with mother, but she can't leave the district without agreement of father, order of court, that would still be preserving what had happened before. But instead it becomes, and father has primary physical custody and mother gets to visit. And we have RK, who's now 6 years old in the 1st grade. And, this is a formative time. And I realize I may be going a little scant, but I was
about to say you're well over your time.
I'm well over my time.
Well, actually, can I ask you a question? Early in the argument, Judge McLeese commented on your use of the word parental kidnapping and suggested maybe concealment was the appropriate word. And my apology to him if I mischaracterized what he said. But here's what I want to ask you. So in the statute setting out the factors to be considered in child custody matters, there's a reference to the rebuttable presumption of joint custody, and then it says that doesn't apply if there is a finding by a preponderance of various things. And one is an intra-family offense, and another is parental kidnapping. What I want to ask you is whether you think that reference to parental kidnapping should be read to cover concealment, as opposed to what we usually think of as kidnapping, as is described in paragraph B of the I'll call it the kidnapping statute, but it does have a concealment section in A and then abduction in B. The question is, do you think that should be read to refer to concealment? And my additional question is whether you think the trial court was correct in treating what happened here as an intra-family offense, because when you look at the definition of intra-family offense, you see that it says something about a punishable offense.
Yeah.
And then, to return to another point that came up earlier, when you look at the defenses to a parental kidnapping, you end up wondering whether this would be a punishable, prosecutable offense.
Yeah.
So if you understand my two questions,
do.
I'll stop talking and let you answer them.
All right. I'm all right. So the first one is, I would say that in terms of how these statutes gel together, I haven't studied, the parental kidnapping as it relates to the others, but here's what I will say. I think that, either we may well prevail in terms of that balancing, if you go into the analysis and diagram it out, as what what parental kidnapping is. What I will say is that even if there's an ambiguity, and I wish I had thought of your point earlier, but even if there's an ambiguity, what I would say is that, the no legislature, Maryland gets it ambiguous all the time. Every legislature does. But what happened when you use the word parental kidnapping and with the listing of other matters, I think this would be viewed as, if you had asked any of city council member of the day, they probably would have said, well, not A. And so you can look at that. I'm not sure if, you programmed it through a computer, if the computer would read it through and say, well, that includes A, the way that parental kidnapping happens. But I just think that the intent was B, whether it's no matter which way you look at that. And as for punishable, I think it's an excellent point. When you say it has to be punishable. So it's 1022, I believe, that has the A and B. But it's then 1024 that has the criminal penalties. And when you look at the criminal penalties that apply, Your Honor, those penalties refer to violations of custody orders. So I think, and you'd have to make a pretty, at least the way that I read that. And so I don't think whether it is that this would actually count in terms of the presumption flipping. And in terms of the presumption flipping, I will further say that the Superior Court didn't even get into that presumption flipping analysis in the first place, didn't say, well, I have flipped the presumption and now I'm dealing with these factors from there. That's not what the Superior Court said. The Superior Court said, I readily find parental kidnapping and both parents are good parents, so this is what I am going to order. And in that time, my client asked for a pendente lite hearing, which would expand the record and be able to make a better record and further show there was no parental kidnapping. I mean, these findings become all the more ridiculous when you get into the actual facts. But what I will say is that wasn't even the analysis the judge did. His analysis was so unmoored from how the statutory factors work that this is manifest error. And we are talking about, these decisions. I've seen one last week or 2 weeks ago, that was 150 pages and took well over a year to come out in another case. This is the girls' lives we're talking about here during this time when core memories are being formed. And, the notion that 18 months or something like that is, well, no harm, no foul, that kind of thing. I was RK's age when my father went to prison for 18 months. And it wasn't until many years later that I learned that it wasn't 3 or 4 years. I mean, that is how long that feels during that period of time. And this court, I think between this case and Cho versus Davis, I would just ask that this court, I know how busy you are, but something that says very quickly and sends this down and says, this was so unmoored from the statutory factors and was so clearly not readily findable as parental kidnapping, that this needs to be sent back down with a clear message to reconsider this case from the atomic level and try not to get into what the first impressions here, because the first impressions were terrible.
Yes, you're well over your time. I think we have your argument. We will give you a few minutes in rebuttal, although it looks like Judge Thompson may have a question.
Well, I was going to ask for your indulgence for one more question. And I was going to point out that you said at the outset that you were not going to argue jurisdictions. You're not challenging the trial court's exercise of jurisdiction. But of course, we have to satisfy ourselves about our own jurisdiction. And since you're over time, let me just ask you to very, very quickly perhaps repeat what you said in your brief. Well, why do we have jurisdiction over this temporary custody order? And why won't the floodgates open if we exercise jurisdiction here? And considering all the other cases we get that involve temporary orders.
Well, Your Honor, I think that In re SCM and Fitzgerald versus Fitzgerald have already said that pendente lite orders are appealable, and these are the floodgates have not opened from those rulings, which have been around for a long time. And this is about children. If we're talking about what's final, we're not talking here about, okay, can parental kidnapping be reviewed from a final judgment? That in the ordinary case, that is the kind of matter you're talking about. What we are talking about here is these girls' lives. That is final. However long it takes for appellate review, of course, that is final in terms of those months and hopefully not years, but possibly in some cases years, that the girls cannot get back. The amount of time that it takes, not just for this opinion comes out, but for the notice of appeal to be filed, for the case to be briefed, to come in front of this court, which is hopefully getting new members soon to alleviate the workload. But I am just, I just want to let you know that if there is any place in which the courts should consider harm irreparable, something to be final, it is final when we're talking about kids. I know that the former Chief Judge, Marianne Barbera, in what we now call the Supreme Court of Maryland, but as she said, the courts have no higher duty, the courts and legislators have no higher duty than protecting children. That is what we do. And protecting children from this. And so is the gravest concern. And if there were any floodgates that were to open, let them open. And I don't think they will, but please, please open this up, because I think under established jurisdiction as to what counts as an injunction, this has the effect of an injunction. This has the effect of pendente lite, because the trial court basically made the temporary into the pendente lite by refusing to hold the hearing. If this were the ordinary temporary until the pendente lite, where there was an actual manifest intent, yes, the temporary is appealable, and then it might become moot depending on what happens at the pendente lite. Now here it wouldn't be moot because of the collateral consequences of a finding of parental kidnapping, no matter what the final decision looks like. But this is the kind of case where, yes, the courts can and the courts should, and they should take as the swift and decisive action, because what was lost here over and over were the factors the city council has said are, this is how you decide the best interests of the children. And what happened here with this rush to judgment without even on reconsideration looking at the factors.
Counsel, can I want to just, I was trying to wrap things up, but you said one thing I just want to make sure I zero in on. I think if I understood what you said a minute ago, you were expressing the view that this matter won't become moot because there is a parental kidnapping / parental concealment finding, which has collateral consequences. Do you mean that's true even if, I know there's been a full trial and we're, the parties are awaiting a ruling on the permanent custody? Are you saying that if there's a permanent custody order and that permanent custody order also has a finding of, rests on a finding of parental kidnapping or parental concealment, that this appeal would still not be moot, and this court should decide it rather than addressing all issues in an appeal from a final judgment, if there is an appeal from that final judgment.
I will say I actually do have a case on this, Your Honor. It is called In Re ER. It is 649 Atlantic 2nd 10. It is a 1994 decision of this court. It was an abuse and neglect case where this court held that an adjudication that a mother neglected her child was not moot because the finding could have collateral consequences for the mother. And
this is potentially a little bit different if assuming there's a final order that has the same collateral consequences that is reviewable, one could wonder whether review should instead be of the final order rather than the more interlocutory order, even if you're treating it as final. So I see your point, but it seems like it's at least potentially different. But I just want to make sure I understood your position.
But even so, but at the same time, there is the risk, as often happens, that the judge will say, well, sure, there was, maybe I'm just going to move on from parental kidnapping. That's in the past. We're not going to worry about that. I'm deciding this fresh. We don't know whether it will be wrapped up in the final judgment.
Oh, well, for sure, it's not moot now.
For sure, not moot now.
That's certainly true.
But there are a great many things can happen. What I know is not if a final custody order should come down during the pendency between now and whenever this court issues an opinion, it will not be moot under In Re ER, no matter what that final order says, unless that order were to say, I was wrong. That I never should have said that. But even then, in the meantime, there are these collateral consequences. There's a finding that needs to be reported. I don't think it has to be reported, but it's this kind of matter that can have collateral consequences for professional reputation. But what I do know is that injunctions are equitable, right? Like that's where the power comes from. And you talk about the equities, and the equities are about irreparable harm. And the harm that is, in waiting for a final judgment in the interest of judicial efficiency is the girls. That's what this is all about. We're here about the girls today.
Thank you. We will hear from you for a few minutes in rebuttal, and we'll hear now from Ms. Ramirez.
Good morning, Your Honors. May it please the court. My name is Leah Ramirez, and I represent the appellee, David Kenney. So I first want to start off with the court's question about whether or not it has jurisdiction. And we respectfully submit that this court does not have jurisdiction. First, I think we all can agree there is no final order. What the appellant is appealing are temporary custody orders to maintain the status quo. And of course, there was a 3-day custody trial and a decision pending. So if there is no final order, then we have to have an interlocutory order that is relating to an injunction. And what I hear from appellant is there's no injunction being appealed. There's a physical custody award that's being appealed. And I just don't see how we get to that being an injunction. And then only if you have that injunction can this court consider exercising its rare discretionary pendant jurisdiction to consider other issues such as the parental kidnapping finding. On the injunction piece, there are 2 cases that were cited by the appellant, In Re SCM. That was an experimental reunification order in a child neglect case. It is not the same, we submit, as a temporary custody order maintaining the status quo.
Can I ask a question about why? I mean, the order at issue uses the word temporary a fair bit, to be sure, but in what sense is it temporary by its terms? Meaning, does it have an endpoint of date or subsequent event when the order will no longer be in effect?
So I think most temporary orders don't have express deadlines, but yes, it was temporary because the case was pending. So it was intended to address during the pendency of the litigation. And there were a couple of requests for pendente lite hearings to address that, which ultimately in April, the parties agreed not to do a pendente lite hearing and proceed to a very, very, I'd say, expedited trial in August. So this trial court acted very swiftly in addressing a pressing custody situation.
Would you agree that this order in effect is a pendant? It's not. It is in effect a pendente lite order.
That's a good question, Your Honor. I would agree that it's a temporary order by its terms, whether or not the court called it a pendente lite order. I think they're the same thing. I think they can be referred to the same thing. So pendente lite, temporary during the pendency of the proceeding. I think it can be looked at as both. Yes, Your Honor, but it was not a.
Well, so I mean, they can be synonymous terms for sure. That's a fair response. But some orders, like the original order in this case, the emergency order was like, I'm going to freeze the status quo until my next, until we have this next hearing. And so that has a very clear, it doesn't have an exact date. Sometimes it'll have an exact date. Sometimes it'll have this order is freezing things until the next event, which isn't the final judgment in the case. It's some other event that's short of that. And those are, sometimes thought of as temporary emergency orders and so characterized. And then other orders are sort of like, here is the order that is going to govern the situation on the ground until there's a final judgment in this case. A lot of times pendente lite is used to describe orders that take that form, although not exclusively. It's a fair point. But this order is like the latter kind. Is it fair to say in that in its effect, this is going to be the custodial arrangement and the obligations of the parties from now until there is a final order in the case. That's the effect of this judgment. Do you agree with that, or do you disagree with that?
Well, partially, Your Honor. So at the time it was entered, I believe the intent was to make it temporary. And then almost immediately, the appellant had asked for a pendente lite hearing. And the court had issued in its order essentially saying the next date I have available is 6 weeks from then, April 4th, 2022. So the intent was to hold a pendente lite hearing. And then when the parties got to that hearing, I accept this is not in the record before the court, Your Honors, but when they got to that hearing, they said, okay, we can get a trial date in August. There's no need for a pendente lite hearing at that point. It would be a waste of the court's resources. So it ended up, I believe, by consent, I would argue, as a pendente lite order, but initially it was intended to be a temporary order, in my view. On the injunction piece, Your Honor, I do think this court's appellate jurisdiction is lacking, and I think that's a really important point. At the In Re SDM case, again, there's a separate interlocutory statute for neglect cases to the extent that's relevant, but that was a change in custody, not a maintaining the status quo order. Then you get to the Fitzgerald case, which appellant argues reviewed a pendente lite order, but the primary issue, well, number one, I believe it was reviewed at the end of the case. And number two, the primary issue in that case was a legislative interpretation of child support guidelines.
Can I ask you, I thought you just characterized this case as a maintaining the status quo order?
Yes, Your Honor, that's
well, the order at issue required that the Ms. Kenney to return the children to the District of Columbia.
Yes,
So
Your Honor.
it seems to have been ordering a change in the immediate status quo. Now, again, you can always try to change the moment at which you are defining the status quo and then figuring out who's maintaining what. But by its terms, it reflects the idea that the world is one way, and rather than keeping the world that way, the order says, no, we have to change the world. Ms. Kenney is required to physically, or to return, doesn't say physically, I guess, herself, but it says she shall return the children. So I guess I'm struggling with the idea that this is a status quo, maintain the status quo order.
So the court looked at the status quo of the history of the family. And then for the prior 6 months, well, number one, the oldest child was enrolled in school. So I think when you're looking at the status quo, getting the oldest child back into the school that she was enrolled and attending and was removed from was certainly an appropriate exercise of discretion to maintain that status quo. The circumstance that Mrs. Kenney created by removing the children, it certainly didn't create a new status quo in my view. The status quo was before she decided to remove the children.
And with respect to who had what kinds of custody, did this order change the status quo or keep it in place? So
in any separating family, there is going to be a different dynamic in terms of a schedule. But this family, the presentation that Mrs. Kenney was the self-declared primary caretaker, I think is incorrect. Both parties.
Well, my question was, again, it's a pretty specific question, which is this order says that the father shall have temporary primary physical custody, temporary, primary physical custody, and that Ms. Kenney shall have visitation. Was that a change to the status quo before the order, or did it keep the status quo before the order in place? Those two components of the order.
I don't think you can look at physical custody as a status quo. So they were living together, caring for these children together. And then you have a family that's together that can no longer be together, right? So we have to address that dynamic that is a little bit different. And it's going to lead to one parent having the children at one time and the other parent having them at another time. And I don't think characterizing Mrs. Kenney's time as visitation accurately captures, what she actually had. So the court.
Well, that's just the trial court's term. I mean, so that may be an issue that you have with the trial court's order, but that's the term the trial court used to describe the state of affairs it was creating.
Right, I understand that, and it wasn't to Your Honor's point; it was to the appellant's point that, essentially she was only granted visitation, but she was granted 3 out of 7 nights every week with the children. I mean, she was seeing the children every single week, as was their father. I mean, you're talking about equal parents. These are, by default, you are the natural joint guardians of your children. And so one parent does not have a greater right than the other. And so returning them to the status quo, I believe returning them to the district where they had their school, had their nanny, and had their father and had their home was an appropriate exercise of discretion. If we even get to that point, and this court has jurisdiction, of course. I don't see, and I didn't hear appellant argue, where there's actually an injunction that is on appeal, that's an issue on appeal. On the, I just want to point out for the court, the Bowie versus Nicholson case, which to Judge Thompson's point, it essentially says that appealing temporary, this was dealing with a temporary support award, but it's because they're capable of modification, which this court rightly said Judge Pittman can modify its temporary custody order at any point in time, and in fact did, to allow the children to have additional time in Chicago. But it says in the Bowie versus Nicholson case, and that's at 705 A2D 290, that appealing temporary orders, which are capable of modification, would cause needless delay and would be contrary to the well-established policy that disfavors piecemeal appeals. So I would submit, Your Honor, that there is no jurisdiction in this court. But I do want to sort of hurry along to address the parental kidnapping aspect. Again, if that fell under this court's pendent jurisdiction, which I respectfully submit it does not. So on the parental kidnapping finding, I accept people don't like these terms. There's an international treaty that addresses child abduction. It has child abduction in the name of the treaty, but then it's never referred to elsewhere. These terms are legal terms, and they can feel wrong, but it doesn't mean that factually it doesn't fit within the definition that this legislature has said is parental kidnapping. I don't think we can change that. So there are different types of, well, I first want to address the 161022. There are 2 subsections for a reason. So you're dealing with subsection A, where the legislature has said, we get it, there's no custody order, but you can still parentally kidnap a child. And they've said, if you are intentionally concealing a child from the other parent who has an absolute right to know where his children are at all times, as much as Mrs. Kenney does. Mrs. Kenney, if the shoe were on the other foot, well, in any event. So there are several authorities that I believe are relevant to the parental kidnapping aspect. So number one, if you're looking at just the trial court's own policy, there's an administrative order, it's 1423, that expressly identifies as emergencies when there's a removal or an imminent removal of a child from the district. I think that is important because even the trial court has said, we want to maintain jurisdiction over children. We want to make sure that they're not just swept off and taken to wherever one parent feels like they can take them. That is not what we're doing here. At number 2, DC Rule 406, it addresses what we call a ne exeat order. It's a Latin term, it means no exit. And that outlines specific remedies for a parent to prohibit the removal of a child from a district if there is a threat of removal. I think that's important as well, because even when there's no custody order, our trial courts have said, and the legislator again has reiterated, you cannot just remove children from a jurisdiction, from the home state jurisdiction.
Well, can I ask you, you're using the word remove, and the word remove is not in the subsection that is at issue. The word is conceal. And so just to give a hypothetical, on the other side of the case, we gave Mr. Klepper some, but if there is marital discord and spouse A, and there's a child in common, and spouse A says to spouse B, or spouse A leaves, and says, I'm going to our the family home in Chicago, and that's where I'm going. I'm going to be here's my route. I'm going to be staying at the condo, and that's where we're going to be. But we need to that's my plan. I know you don't agree with it, but that's what I'm doing. That would be removing the child, but it seems like that doesn't fit well with the word conceal. Unless there's reason to believe that spouse A is lying, spouse B will know exactly where the child is. Is it your view that concealment isn't even required and all that is required is removal, or do you agree that there has to be concealment to be a violation of A?
Right. To be a violation of A, I agree, Your Honor, there has to be intentional concealment. That's what the plain wording of the statute reads.
So then it seems somewhat overbroad to be relying on the idea that there are concerns about unilateral parental removal. Those are, I can understand why those create problems and there would be concerns about them, but I'm not quite sure that, I don't think this statute captures all parental removal. It captures some subset of parental removal or parental taking that results in, or that is accompanied by intentional concealment. And it sounds like you agree. So what's your, do you have a test for us about what amounts to concealment and what kind of intent is required to violate the statute?
Sure, Your Honor. So I think the intent piece of this is clear because Mrs. Kenney has admitted to her intentional actions, but the concealment piece, and I had outlined in my brief, using Black's Law Dictionary, trying to come up with a workable standard. One of the, bear with me, Your Honors. The concealment as defined by Black's Law Dictionary would be an affirmative act intended or known to be likely to keep another from learning of a fact of which he otherwise would have learned. So under the court's hypothetical, I agree with Your Honor, if she were not being truthful about disclosing factual information about the children's whereabouts, that could still amount to concealment. But if she had said, this is where the children are, latitude and longitude, you can find them, is that concealment? I think we'd have a hard time arguing that that's actually concealing the children. I think it's more akin to a removal. What I think is important is there are express remedies in the statute for Ms. Kenney to address the actions that she took. If you look at,
before you move off to that, I just want to keep focused on getting your standards for concealment, because one of the things I struggle with under the statute is it doesn't really seem to have a wrongfulness term in it. And, I don't know how familiar you are with the case Mr. Klepper was mentioning, the Cho versus Davis case, where some of the members of this division and another judge were touching on some of the same questions. But one of the hypotheticals that came up there, if memory vaguely serves, is hide and seek. So if parent A and parent B get along wonderfully and they are playing a game of hide and seek with the child, and the parent A says to the child, go hide in such and such a place. And then spouse B playing the game says, well, where's the child? And spouse A says, I'm not telling. It seems like that's intentionally concealing the child. The child is out of view. The parent wants, the parent is asking where the child is. It can't be that that's a crime. And so the question is, unless you think that's a crime, which I can't imagine you're going to say, so I'm going to take as a given that you're going to say, no, that's not a crime. That doesn't fit within the statute. But can you tell me or help me which of the terms, intentional or concealment, you think makes that not a crime, and what lines you think get drawn?
So I think it goes to the defenses that are outlined in the statute, and one of them is consent. And so in your hypothetical, Your Honor, I think it could be argued that the parents were consenting to that type of concealment, right?
Okay,
So,
that's a good answer. That's an excellent answer. How about a hypothetical that involves a surprise party?
I would have the same response if it's a
Like
surprise.
implicit consent,
Oh,
sort of
right.
implicit consent?
I don't know, Your Honor. I think it could be implicit consent there. I think
And if spouse A takes child on an errand without informing spouse B, and spouse B is wondering, where's the child? That's an intentional act by spouse A. It is an act that operates to conceal in the sense of meaning that spouse B does not know where the child is.
Yeah.
Is that intentional concealment and a crime? It can't be. But what's missing? I mean, that's an affirmative act, an intentional affirmative act that has the effect of meaning that spouse B doesn't have information about the awareness, the precise location of the child. So what do we add into the words like intentional or concealment to get rid of hypotheticals like that, but capture conduct like is at issue in your case?
Right. I mean, I think if a parent is asking, where are my children? I want to make sure they're safe. They have a right to know that information. And if the other person intentionally withholds that information, it's not their right to withhold. So they can withhold under certain expressly identified circumstances, but that's it. It is just as much parent A's child as it is parent B's child. I think that's lost here. But that I would argue. And I would also say
So can I just ask that makes it sound like it is intentional concealment in the face of a demand? Because the hypothetical is about like the errand. There isn't a demand. It's true that the spouse A is off with child B or with the child, and spouse B doesn't know. But if the hypothetical is then the spouse B comes home and doesn't see spouse A and the child. And again, assume no marital discord at all. This is just everyday life. And spouse B says, texts spouse A and says, "Where are you?"
Mm-hmm.
And spouse A doesn't respond, and comes back a couple hours later, and spouse B is kind of mad. And spouse A says, "Yeah, I saw your email. I figured I'd tell you when I got home." Would you say that's a crime?
Well, in terms of crime, I would say that it's different standard under the Inter-Family Offense Act.
Well, I'm not sure that. Why do you say that?
My point there is it's a preponderance of the evidence standard for parental kidnapping.
There's a different burden of proof, but the question still would be, those are undisputed facts. So let's take those as undisputed facts. The issue, I don't think, would be burden of proof in that hypothetical. So I think either way, either the answer is yes for purposes of these custody determinations, as well as for purposes of the offense that's created here. And either way, so would you say in the hypothetical I just gave, there's a demand for information and a non-response?
So I suppose it depends if it was intentional or not to respond at that point.
No, imagine that the spouse came back and said, "Yeah, I knew you wanted to know, but I was busy. I figured it'd be fine. I figured it'd be fine if I let you know when I got back where we had gone."
I think
so the intentional delay in responding. But not out of any malice or anything like that. Everybody's getting along. It's just, my priorities were, you wanted to know exactly where I was with the child at this exact moment. And I didn't really have that as my, that wasn't my highest priority. So I was going to tell you when I got home.
Okay. I think in the court's hypothetical, intentionality is the primary issue and not the concealment. And the intentionality is somewhat lacking. I do think a good segue is to the Fleet case, which even the trial court, while the trial court here found the Fleet case instructive, but not directly on point because it was a different subsection, I do think it's noteworthy that the trial court in Fleet did find that the father concealed the child under subsection A by merely taking the child into his office for a few minutes.
But in Fleet, we had a custody order already in place, and so the scenario was much clearer. We weren't under this self-help regime. And sorry, Judge McLeese, did you have a question?
Well, I was just going to comment. I mean, you're quite right. The trial court found that the Court of Appeals did not address that question and instead relied on other subsections. So it's not a precedent from this court on the question of whether the circumstances of Fleet would have amounted to concealment under A.
Right, of course.
And so where I wanted to follow up with you from there was, when we're in this self-help regime stage of things, and I'm probably gonna have a couple questions for you out of this, but where do one parent's rights end and the other parent's rights begin in this? I'm thinking specifically about this January 30th scenario.
So it's my position, and I believe the law supports this, that you're equal joint custodians of your children until you're not, right? Until a court says something other, you are equal custodians. So on January 30th, Mr. Kenney, if he wanted to, could have taken the children back to the district. There was nothing prohibiting him from doing that. I suppose, he was subjecting himself perhaps to the same claims that are made against Mrs. Kenney, but they both had equal rights to the children at that point. Did that answer Your Honor's question?
I mean, it does, but it leaves things, the idea that he would be open to the same claims, which would have been a follow-up question. I mean, it's just trying to figure out where to balance this before there's an order in place, really defining the official status quo seems difficult, but also in terms of this concealment aspect of it, how specific does someone need to be in disclosing?
It's a good question, Your Honor. I think it's a factual analysis. It depends on, what information is asked for or what information is being withheld about the children's whereabouts. I mean, if we're only talking about concealing children, in my mind, that is, where are the children? What are their whereabouts? And the trial court here found that, 5 hours later, this is back to the January 20th, when Mrs. Kenney said, I'm 3 hours away from the Chicago condominium. That was enough. That's what the trial court found, that was enough to sort of disclose the children's whereabouts, and the concealment at that point, that was a series of 5 hours, had concluded.
Can I ask you, you said that your position is that on the January 30, on the date of the January 30th, on January 30th, your client would have been acting lawfully by removing the children back to DC. I wonder how that squares with the characterization by the trial court of Ms. Kenney's statements in early January of an intent to leave with the children to Chicago as a threat of parental kidnapping. Because it sounds like your position is she had the lawful authority, if she wasn't hiding the relevant information, to take the children with her to Chicago. There was no order. And so if she had said, okay, sorry, we're going to Chicago, that's not a threat of parental kidnapping. That is a statement of, it's a threat to unilaterally remove the children, which I thought you said before, if there isn't concealment, doesn't violate subsection A.
The mere threat of removing the children, I believe, would be addressed by an exeat statute. I
get that, but my only point is, do you agree that when the trial court characterizes in its order of what Ms. Kenney said in early January as a threat of parental kidnapping, that's incorrect? Because that conduct without concealment is not a threat of parental kidnapping.
Just trying to process your Honor's question. I don't think the trial court found that the January 13th threat was parental kidnapping. Do I think it's a threat of parental kidnapping? Potentially. I think it's a fact that led into her intentional concealment, but I don't think that particular threat changed or bolstered the court's analysis of what actions Mrs. Kenney took on January 20th and January 30th.
I know you're over time, and I know we didn't hold Mr. Klepper to his either, but there are a separate set of topics. We've been discussing concealment, but Mr. Klepper has kind of a second level challenge to the temporary custody order as not reflecting an adequate balancing of all the relevant considerations. I mean, first he has the argument that if there was no parental concealment, then the custody order rests on a mistaken premise and would have to be rethought. So there's that argument. But he makes, I think, a separate argument, which is in any event, the trial court kind of gave undue focus to the finding of parental concealment and didn't really work through explicitly or implicitly the other factors that a trial judge ought to be considering before entering an order of this kind. And I wanted to give you a chance to address that contention.
I appreciate that, Your Honor. So with respect to the temporary custody award, number one, we start with the abuse of discretion standard. And I believe there's no clear basis to find that the court abused, there's a manifest abuse of discretion. The trial court held 2 hearings. Parties testified, counsel submitted argument. The trial court made findings on the record in both of those hearings. He entered very detailed subsequent written orders. And the PF versus NC case says that it would be illogical to conclude that an intrafamily offense finding would be a neutral factor. The trial court did exactly what it was required to do under the statute, which is to address the presumption of joint custody, address the intrafamily offense finding, and then make a custody award. And it stated that it was considering the factors outlined in DC Code 16914. And again, this was an order to maintain the status quo. I do think that the record, which was considered, the transcripts, the parties' very detailed filings under oath, the paper signed, that the court considered the factors it found relevant, either expressly or implicitly, for a temporary award of custody. And ultimately, Your Honor, I do think it's important that it didn't result in a sort of imbalance of custody. We're talking about a approximately 60 to 40% ratio of time with the children. And not to mention, I know, again, this is not before the court, which is unfortunate because it's part of the piecemeal appeal argument, but it ended up as the parties had about 50-50 time because they agreed otherwise, which the court had always maintained the flexibility for the parties to do. And I believe the trial court's assumption correctly, because Mrs. Kenney took this position, is she's staying in Chicago. And so he assumed that if the children are back in their status quo in the district, older child's back in school, younger child has her nanny, that this was a workable schedule for this family on a temporary basis. And of course, we're going to have much more ample evidence in a final order because we both submitted 70-page proposed findings of fact and conclusions of law. There's a very detailed record forthcoming, of course. So
Can I ask you that is a natural transition to the topic that came up during your opponent's argument about the potential mootness or not of this appeal if before we are able to resolve it, there is a final custody order. Do you have a reaction to that topic?
I would say right. Is it moot right now as we sit here today? No, but will it be by a trial court subsequent decision? Yes, the whole order is going to be addressed in a permanent final custody order. Any temporary custody order is going to have a following subsequent permanent custody order. And the court's decisions on a temporary basis are going to be addressed in a permanent order. Yes, it's going to be moot. I don't think there's any way around that. Would the parental kidnapping finding be moot? It depends what the trial court finds in its final order, but I would say there was no facts in the record to change that decision. Your Honor, just on I won't go into the home state jurisdiction or any piece like that because I just learned today that the appellant's not pursuing that, but I just want to say the district court had home state priority jurisdiction. It could act immediately. It did not have to wait until the Illinois court did anything under the UCCJEA, under the Uniform Law Commission commentary. I think that's very, very clear. that the trial court could act immediately on the basis that it had home state jurisdiction.
All right, thank you, counsel. Unless you have anything further or my colleagues have further questions, we will proceed now and give Mr. Klepper, I forget whether he asked for 3 minutes or 4 minutes, 3 minutes for rebuttal. You're muted, Mr. Klepper.
I did ask for 3. I remember that, but all right. Very quickly, there are just some corrections, saying there was not a consent to not have a pendente lite hearing. We specifically requested and was specifically denied. And we did want to get this to trial when we could, but none of this affects how long it takes until the end of the custody matter for what is effectively pendente lite to be resolved. And this case was a rushed judgment that turned these kids' lives upside down. On jurisdiction is a functional analysis, and functionally what this did, as this court points out, required my client to bring the children back to the district, and she complied lawfully, and then she challenged it lawfully. I heard that there's an absolute right to know where the child is at all times, or at the very least when one demands. Where is that? The statute was written in 1986, Your Honor. There was no conception. I have memories of waiting 4 hours when somebody took a different turn along the way, stopped somewhere. You just didn't know where people were in the 1980s. In terms of the hypotheticals involving the facts involving January 30th, this again, no matter what you want to say about conceal, it gets the difference between intentional and knowing. Because in the criminal law, knowing means you know that there's a consequence, even if that's a collateral intent. But intentionally means you need to intend that effect. And so if my client's intent was to avoid conflict in front of the girls, that is a reason, or even if a knowing concealment happens as a result, as a natural and probable consequence, that is still not, as long as the intent was to avoid conflict.
The way you say that makes it sound like people can only have one intent. And so if I have one, I couldn't have had any others. But if your client, assume this amounts to concealment, which is part of what we need to decide. Yeah. But if it's concealment if your client was saying, I'm going to hide the children, that's my means. So I wouldn't do that normally, but that's my means because I want to prevent conflict. If, that might fit into a defense perhaps, but I'm not sure that. I just was wondering about the way you were wording your point, because it seemed to reflect the idea that if I have intent A, I can't also have intent B.
But what I think is Your Honor, in terms of knowing, there is a difference between intentional and knowing in the criminal law, which
for sure. But you can intend.
But if the intent, as expressed at the time, it was expressed up front. If you want to see the kids and not take them back, you get to see them. This wasn't an intent to conceal them from the father. If it was an intent also to avoid him taking them back to the district, that's not concealment, that's avoiding removal. And removal is something that is stated in subsection B, but not subsection A. And in terms of Fleet being instructive, the only point on which it is precedential is this court saying that concealment, we're not reaching it because it requires something more. There's a something more, an affirmative act of concealment, as I recall the court saying. And the trial judge reached out. Nobody mentioned Fleet. And I've read Fleet and it seems instructive without any briefing. It is neutral or it goes against his ruling, which gets back to the very human reaction when you see a family to make some snap judgments. This isn't how I would do things. This feels wrong and I should do something right now. And that is a human reaction. And the reason we have these statutory factors is to say, no, we have the law. Do not make snap decisions. And the feeling that the Superior Court had to step in and rectify. And I will say, no, the Chicago court was the first to file jurisdiction. We are not conceding what was the home state. We are merely saying we are not seeking the relief of ordering a new finding on form because we don't want to have a new merits trial. Finally, I know I've gone a little over. This notion that we held hearings, each of these was noted as a non-evidentiary status hearing, where suddenly it became a free-for-all and the judge hearing some testimony, but not a chance to develop. When you marshal testimony and evidence, I've heard a lot of proffers about how things turned out. You know, if we want to get into proffers, the father changed his story at the merits hearing of what my client said at the argument on January 12th. He suddenly said, in the heat of it, she said she was going to take the kids and make sure I never saw them again. That was his testimony at the merits hearing after his motions only said she was going to take the kids back to Chicago. So there are so many things that would have been developed if there had been a full chance with due process to marshal testimony. And instead we have a snap judgment that has turned these kids' lives, you know, let's not underestimate, oh, you know, the percentages. There is an impact on the children's lives. So.
Thank you to both counsel for your arguments today and for your briefs. And we will take the case under advisement, and the court will now be in recess, and you are both free to leave the virtual courtroom.
Thank you so much, Your Honor.
This court is now adjourned.